Yes, Mr.
Thank you, my lord. My lady, my lords, before the short adjournment, we had a short debate in relation to the Transero shares and the SkyTeam shares. And I should have added then, and I add now, that it definitely is no longer, although it certainly was, a dispute about the Transero shares. And it's no longer a dispute about Transero shares at all, because they are dead. They are worthless beyond worthless. Shortly after the hearing in the Court of Appeal, Transaero Airlines lost their license and in October 2015 went bankrupt. And they went bankrupt with a debt of 3.9 billion euro. And Mr. Pleshakov has left Russia. So we are no longer concerned with the asset that was of Skystream in the shape of Transaero shares. I thought I ought to have made that clear. Now, I had addressed the board about the need to establish intention on the part of the bear trustee that is here argued for. And as the board knows, what we do not have in this case is any declaration of trust by Mr. Linkov or Ms. Kazantseva, such as, quote, "We and each of us will hold the shares in Skystream, which are registered in our names on trust for Mr. Pleshakov," unquote. And no such case was ever put to either of them, nor was there any finding to the effect that they might have made any such declaration or evinced an intention in those terms. If the requisite intention is to be established by inference, then in our submission, this inference would have to be necessary and unambiguous on the part of each, Mr. Linkov and Ms. Kazantseva, based on the clearest evidence. And there would also need to be an express and reasoned finding of the formation of that intention on the part of each of them separately. It was not one of the submissions made to the Court of Appeal that there had been the formation of any such intention, nor, of course, could it have been said that there was a finding of the formation of that intention in the terms I have put forward. My lady, my lords, we have in our written case at page 2349, under the heading, "The necessary intention to create a bear trust," set out some of the authorities, which, with your permission, I will just mention without taking you through the huge bundles, but we have given the correct electronic bundle references. We say in our paragraph 82, as to the settlor's intention, this must be clear, and I had already referred to this from Snell's Equity before the short adjournment. Then in 83, we refer to night and night with sufficient certainty, a case, of course, you are very familiar with. And then we say in paragraph 84, it is insufficient to show a mere intention that one person hold property for another. It must be possible to discern the powers possessed and duties owed by the holder of the property. It must be demonstrated that the holder of the property in question intended to owe the legally enforceable duties of trustee. Now, my lady, my lords, this to us is one of our most central submissions in this case, because we have this dichotomy of it being said on the one hand, oh, well, a nominee is a bear trustee. Well, no great debate about that. But then a bear trustee has no duties. I'll come to that shortly hereafter. So why have we got a setup where Mr. Linkoff and Ms. Kazantzeva are entirely in charge? And I will come back to that as well. At paragraph 85, we refer to later cases, in particular Dipple and Corliss, Sir William Page Wood, the Vice Chancellor, and we quote from his judgment, "It appears to me that a clear expression of intention should be found before the court, in a case like the present, can hold that a party intended to subject himself to all the consequences of the liability to answer an inquiry which is involved in the position of trustee." Again, we very much emphasize that requirement. We then quote from Reeve Williams, Lord Lindley, "There can be no doubt that equitable obligations, whether trusts or conditions, can be imposed on any language which is clear enough to show an intention to impass an obligation and is definite enough to enable the court to ascertain what the precise obligation is and in whose favor it is to be performed." And my lord, my lady, in our submission, the judge didn't do that. We do not find a finding on his part as to what were the duties of Mr. Linkoff and Ms. Kazantzeva that they had voluntarily assumed vis-a-vis Mr. Pleshakov, which were the legally enforceable duties that they owed him as trustees. In paragraph 87, we submit the rationale for requiring evidence of an intention that the party's trustee owe legally enforceable obligations of trusteeship to the putative beneficiary is clear, particularly in cases where there is no unambiguous declaration of trust. Like here, the factual circumstances from which one could infer an intention to create a trust will often be the same as or similar to the factual circumstances from which one could infer the existence of some other kind of legal or indeed social relationship. There must therefore be evidence that the relationship in question is one of settlor, trustee, beneficiary, rather than some other kind of relationship. Hence the need for evidence that the putative trustee intended to owe the particular legal obligations of trustee. That's what we needed here. And as was already submitted, my lady, my lords, in answer to questions of my lady Arden, here we appear to have an allegation that the respondents are both settlor and trustees. We say at paragraph 88, the authorities have consistently stressed that it is true that by use possibly of unguarded language, a person may create a trust without knowing it, but unless an intention to create a trust is clearly to be collected from the language and the circumstances of the case, I think that the court ought not be astute to discover indications of such intentions, and that is the case of Shepsman, which is at page 3743, and this quote comes from page 3722. So my lady, my lords, we submit, as we do in paragraph 90, that there was no positive finding by Justice Bannister that either Mr. Linkoff or Ms. Kazantzeva had such an intention to create a trust. And we set all this out. And there was no safe basis for the Court of Appeal to have concluded that the judge was right in such a finding, because he didn't make it. He hadn't made a sufficient finding of fact to support this formation of intention by each of them, that they would be one trustee and two have specific duties enforceable in law vis-a-vis Mr. Pleshakov. Now, My lady, my lords, of course, we feel embarrassed to address the board, constituted as it is, on the proposition as to what is a bare trust. We do understand that it can arise in many circumstances, and it is well encapsulated in our submission by Lewin, and that's at page 4313, where the learned editors refer to the bare trustee being a passive repository, a passive repository. And Snell, whom we cite, our written case at paragraph 42, page 2331, and the passage is at page 4377, says the bare trustee has no active duties. His sole duty is to convey the entire property, of course, to the beneficiary. So that is a bare trustee. A bare trustee has no beneficial interest himself at all. Beneficial interest is always the beneficiary. But the bare trustee holds the property, as it were, passively for the beneficiary, who can, if absolutely and indefeasibly entitled, simply alter it. And then he must convey it. That is his duty. That is what he must do. Nothing else. Nothing else. So, my lords, we have set out at our paragraph 43 of the written case at page 2332 a series of authorities dealing with bare trust and the absence of active duties owed by a bare trustee. We have already referred, my lady, my lords.
Could I just ask a question?
Yes,
I'm
my
so
lady.
sorry. Could I just ask a question? I noticed that Lewin puts it very narrowly there as simply a duty to transfer if that is what the beneficiary asks him to do.
Yes, my lady.
But there are other rights of attaching to property which the beneficiary may ask him to exercise. And we saw a different expression in Thomas and Hudson about must exercise stewardship. If there is some other right attached to the property which the beneficiary asks him to exercise, would not the same principle apply?
Well, my lady, it does depend, does it not, on what exactly we're looking at. If we're looking at, for example, the beneficiary having a beneficial interest in the building, and the beneficiary says to the trustee, well, is it insured? You can well see that the stewardship would include insuring the property which is held for the benefit of this beneficiary. However, and I will of course come to it in a little more detail, this is not this case. This is a case where you are supposed to have, on the one hand, a bare trustee, but on the other hand, a host of tasks of active management of effectively a trading company. That is very different indeed from the bare trustee whom we come across in the authorities and who normally can only be asked to do very few things indeed. In the long list of authorities, and we've cited some, and I'll come to them in a minute, it is not ever, I think I can safely say ever, the case that you have a bare trustee who can be directed by a beneficiary to manage a business.
Well, in this case, 2 points shortly. One is that they were directors, and obviously powers of management were vested in them as directors. That's the two personal respondents. The second point is that it's very common for custodians to act as holders of shares, and we're talking particularly about shares, and they are expected to vote if that is what the beneficiary wants them to do in a normal custody.
My lady, if I may address both of these. First of all, the custodian. The custodian, and I suspect many of us have shares in bank custody or in some fund trust deposit, and the depository will charge us fees for holding the shares, and we expect them to hold them safely. If there's a question of voting, it's an exception, but nevertheless it can occur, then the trustee, as we've seen in the cases, does his best as he sees fit, but the beneficiary may voice a request as to how the shares should be voted. But in my submission, that is an exception. When it comes to the wider activities that take place, then, as my lady says, of course, here, Mr. Linkov, Ms. Kazantseva were both board directors, and as directors of a company, they owe duties as directors of the company to the company to manage it in the interest of the company. And they have all those obligations, and nobody has ever suggested that they didn't fulfill them. They did. We say, my lady, they did so because they were the directors. Mr. Pleshakov says, well, they had to do what I wanted them to do in relation to a whole series of things, and in particular the trading. So, my lady, we are not saying to the board there wasn't a bare trusteeship in theory on Mr. Pleshakov's case somewhere. That is evident and has been stated many times. The problem is that he falls in the hole of what is the genesis of the trusteeship, one, the bare trusteeship, and two, how come that, although Kazantseva and Linkov are bare trustees, they do actual management of the company. That is the problem. And that is on the authorities, my lady, not the case of a bare trustee. Now, of course, and I make it clear immediately, we all know very well that what you have in the British Virgin Islands and in numerous other offshore and other jurisdictions are nominee agreements where the nominees provide, their nominee shareholders provided, nominee directors are provided, and there's a nominee agreement which sets out the legally enforceable duties of those directors. But that is not this case. This is not what Mr. Pleshakov was ever able to establish. There is no, this is the problem, that he says, oh, there was an agreement. And then they said, no, there was no agreement. Please, we don't need an agreement. The bare trust deus ex machina arises from the miasma somewhere, somehow. So I'm coming to our paragraph 43 at page 2331, where we say and submit, my lady, my lords, the duty of a bare trustee is therefore a limited and particular one. We refer to conveyance, and we particularly emphasize the decision of the Federal Court in Australia in the Herdigan case, which addresses this very well, and the case is later cited elsewhere. And they held, and you have the reference in the margin to the authorities bundle, that a bare trust is, quote, a trust under which the trustee or trustees hold property without any interest therein, other than that existing by reason of the office and the legal title as trustee, and without any further duty to perform, except to convey it upon demand to the beneficiaries or beneficiaries as directed by them. To the extent that this is now no longer a quote, to the extent that the bare trustee has any duties pending the conveyance of the trust property, these are only for the purposes of guarding the trust property, such as the property simply, quote, awaits transfer to the beneficiaries or their direction. At their direction. Now, the court in Hong Kong, Court of Appeal, in Hotung held also that a bare trustee is not bound to follow a direction to execute a power of attorney in favor of beneficiaries. The Hong Kong court drew on the clear line of English authority in relation to special trusts holding that an absolutely entitled beneficiary can exercise his or her Saunders and Voti right to demand the transfer of the property, but cannot otherwise direct the trustee how to exercise his functions. And then we refer, consistent with those authorities, to the decision of the English Court of Appeal in Lashmar. Again, you have the bundle reference in the margin, expressing the view that a bare trustee has no duty whatever to perform for Lord Linley. And further English case law suggests the possibility of one limited exception requiring a bare trustee of shares to follow the beneficiary's instruction as to exercise their voting rights. So the point of my Lady Arden. But this exception has been treated as anomalous and restrictively interpreted. And we then say in 43.4, Mr. Pleshakov has never sought to contend that such a voting exception is or should be recognized in the British Virgin Islands. In any event, any voting exception has no relevance on the facts of the present case. The exception, even if it would apply only to the trustees' exercise of voting rights qua shareholders, it would not permit the beneficiary to give binding instructions to the trust, to the directors of the company, as to the exercise of their powers qua officers of the company. And indeed, we have seen that Mr. Linkoff and Ms. Kazantseva, in fact, over the years, passed various board resolutions entirely as they saw fit. Indeed, they passed a resolution altering the articles, and they passed resolutions, including when Mr. Pleshakov and his daughter briefly came upon the board, that Mr. Linkoff alone should be the director who could bind the company and could make all its decisions. So we say at paragraph 44, in sum, the authorities make consistently clear that the role of a bare trustee is a strictly limited one. In particular, the beneficiary of a bare trust is not entitled to give binding instructions in respect of the active management of the company. If he wants to do that, he has to have an agreement. Now, we put against this line of authority, which is really clear, the evidence, where we can say without any exaggeration, is overwhelming, that Mr. Pleshakov wanted active management from Mr. Linkoff. I do not add in Ms. Kazantseva, because actually, and I come to this separately, Ms. Kazantseva didn't exist for Mr. Pleshakov. He says so in terms, he's hardly ever met her, he places no trust in her, and he isn't interested in her at all. Nevertheless, apparently, she's a trustee. My lady, my lords, we address the question of the active management at page 2337 of our written case, paragraphs 56 to 58. These are just examples from what was a very great deal of evidence. And we say in paragraph 56 that Mr. Pleshakov said in his second affidavit that he reached an oral agreement during the course of a number of meetings with Mr. Linkoff held in Moscow in 2005, late 2005. Dutch didn't accept that because Linkoff wasn't in Russia until very much later. In particular, his evidence was that Mr. Linkoff said that in the same way he had managed Walsham, another company, on my behalf, he would be happy to act as managing director and registered shareholder of his new company. And we agreed that Mr. Linkoff and Ms. Kazantseva would each receive a monthly salary of €4,000 for their management of the new company. Mr. Pleshakov further explained the nature of the alleged arrangement as follows. although the company was incorporated to hold shares in Transaero on my behalf, it was never intended by me that it would just be a holding company. In fact, Mr. Linkoff and Ms. Kazantseva, on my instruction, forced the company to buy and sell shares in Transaero and use the proceeds of the various sales to acquire, among other things, a property in Florida. The company was therefore a useful tool in the management of my assets for the benefit of both me and my family. My lords, my lady, we have given references at the bottom of the page for all these quotes. It's quicker to see them here than in the very large bundle. And Mr. Pleshakov gave the same account in his third affidavit, repeated his unequivocal assertion that it was never intended by me that Skystream would just be a holding company, and that instead the company was a useful tool in the management of my assets. And we give you further quotation from that. I won't all read out because you have it. And in paragraph 58, we have his witness statement for the trial. And he gave up the suggestion there were meetings in Moscow because it was physically impossible, since Mr. Linkoff approved with his passports, that he wasn't there. And he says, I cannot now remember the exact dates or locations, but he went on to emphasize the active management and said, until recently, Mr. Linkoff and Ms. Kazantseva followed my instructions in relation to the company and have managed its affairs at my behest. It's impossible for their trustee to be legally obliged to take such instructions unless there is an agreement to that effect.
Can I just ask you a question? I'm struggling to understand why it matters whether the trust was a bare trust with what you acknowledge to be an obligation to convey the trust property on demand, or a bare trust plus, i.e. with that obligation and other obligations such as to manage the trust property at the direction of the beneficiary, in a case where the claim is not that the property has been mismanaged, but there is a dispute whether there's a trust at all, and where the claim is simply for a conveyance of the trust property.
Yes, my lord, I could really do without Mr. Warren's, his facial expressions and grimaces and noddings and so on.
Well, don't worry
it would be
about
appreciated if he refrained from behaving like that. However, answering your question, my lord, of course, we completely agree with your lordship. The only reason why we are emphasizing the difference between a bare trustee and a situation where, as my lord says, you have a trustee with obligations plus, is that we are accused, Sir Clive Friedman and I, of having misled the Court of Appeal. This is paragraph 17 of the written case of Mr. Levy, stressing that there was an oral agreement. And it is to us and our submission clear that you simply couldn't have this bare trust case without the plus. Otherwise, there is nothing to it. You can't just have a bare trust on the facts of this case. There had to be a plus, namely an agreement. And it's the agreement that Mr. Pleshakov simply couldn't establish. And we kept submitting this, and my learned friend, Mr. Mouskinson, before the Court of Appeal, and I come to that, emphasized that there was indeed an oral agreement. That was the building block upon which Mr. Pleshakov put his case. Because otherwise, as I say, what on earth was the genesis of the bare trust? There is no genesis that we can find. There had to be an agreement. And as part and parcel of the agreement, Mr. Linkoff and Ms. Kazantseva, each and one of them separately, agreed to be trustees holding all the duties of trustees, and agreed to follow the instructions they would be given from time to time from Mr. Pleshakov. So yes, the case has to be bare trust plus.
But one has to be quite clear about what this this extra plus comprises and what it does not have to comprise. It does not have to use the words bare trust or nominee.
No.
It simply has to be an inference from the totality of the arrangements between the parties that the property in the shares was to belong to Mr. Pleshakov. That has to be the proper inference from all the rest of their actings and agreement and
Yes.
words used. It doesn't have to be an express term.
Well, my lady, we are, of course, in a situation where we don't have express declarations or even written agreements or anything of the kind. So I have already submitted, and I, of course, stand by that submission, that a bare trust can arise from all the circumstances. And you then need to look at those circumstances, whether you can genuinely distill from them the formation of the intention, and it's clear and unambiguous. And I have already submitted that such a finding of clear, unambiguous intention needs to be made in a reasoned finding that sets out precisely when each of Linkov and Kazantseva formed that intention, how they did so, what duties they assumed. And it had to happen before the date of incorporation, which was the 14th of December 2005. So that is the position.
Why does it have to occur before the incorporation? It has to occur at some point, I agree, but why before the incorporation?
Well, that's when they became the registered shareholders of the company. They set it up.
It could have been.
And at that point of acquiring the company, acquiring the shares, having it registered, they were the legal and beneficial owners. No question. So something would have had to happen for them to say, right, we are now declaring ourselves trustees for the shares that we own in Skystream.
But the judge rejected the evidence that they were forming the company for their own benefit. He didn't accept that.
Well, the judge didn't accept that, my lady. That is, of course, so, which is why we appealed. And the Court of Appeal was able to evaluate itself on the same material that that intention was not made out.
But why was the judge, I'm only putting this to you because it's a key issue, I'm not expressing a view, why wasn't the judge entitled to form a view about that? It's a question of fact, isn't it? And of inference from hearing the evidence.
Well, my lord, my lady, it's very hard to address that in circumstances where the judge hasn't actually made a finding of formation of intention on the part of each of Linkov and Kazantseva, and said, and this shows to me that he attended because he did this, that, or those are the circumstances upon which from which I deduce clearly and unambiguously that that is Mr. Linkov's intention, and that's when he formed it. Because, as I say, the incorporation was on the 14th of December 2005. Never mind Ms. Kazantseva, who was forever ignored by most of the protagonists in the case. But she too is meant to be a trustee and to have formed this intention and assumed those legal duties and agreed, as my Lord Brick says, the plus to follow all instructions faithfully and manage the company as directed by the alleged beneficiary, Mr. Pleshakov. So, my lady, the point you make is obviously right in the sense that a judge can come from circumstances to such a conclusion. However, we submit that here he hasn't done it properly. And the Court of Appeal agreed with us. It said the Court of Appeal was wrong. And it said that the Court of Appeal doesn't sufficiently focus on the arising of a trust. And I will, of course, come to this separately because it's part of my task to do
So
that.
to be clear, it's not a perversity challenge, it's a reasons challenge.
I'm sorry, my lady, I didn't understand.
In relation to the judge, it said he was, just taking your last answer, he was entitled to draw the inferences, but he didn't actually reason it.
No, my lord and my lady, I didn't refer to Mr. Justice or to Justice Bannister in saying what I said a moment ago. What I said was that I, of course, agree with my lady, Lady Arden, that a judge can look at circumstances and deduce from them that there was here a clear and unambiguous intention to hold a property on trust. Of course, a judge can do that. And I've already shown authority to the effect that you can take the arising of a trust, not only from a declaration, but also from circumstances. But they have to be very clear, very unambiguous. You have to find them specifically. You have to say, which is it that you refer to? And in my very respectful submission, my lady, my lords, I do submit that you cannot just say, oh, well, I look at everything. It makes an impression on me. Here's an impressionist painting. And the impression I gather from all of it, having looked at it and heard it and perhaps looked at it again, is X. No, you can't do that, unfortunately. It would be very easy for one as a judge or arbitrator or whatever decision maker one may be to do so. But unfortunately, one can't do that. One has to give proper reasons and real findings of real fact, which are identified with their specific circumstances. And we say, in this case, date, because look at the registration of the company. So, my lady, of course, I am very happy at all times to be interrupted, to be asked questions. In fact, I welcome it greatly because I would be very sorry if I hadn't explained our case correctly. I have already said that I will deal separately with the specific situation of Ms. Kazantseva. I will deal separately with the case before the Court of Appeal and with its judgment, and at the end, briefly, with the delay that was caused and the points, if anyone draws from that. I would, in the meantime, though, first go to the issue of subsequent conduct. Now, of course, the judge recognized, but did not exactly comply with his own direction, that subsequent conduct is not really the point. You need to look at what surrounds the incorporation of the company and not what happens 5 years, 7 years hence. He was right in that, but he didn't stick to it. Now, I will nonetheless go through the various points that are raised. Now, one that is nearest in point of time to the incorporation of the company is the trust deed. And you have already seen it. I won't take you back to it. And our case on the trust deed is fully set out at paragraphs 93 to 96 of our written case at page 2353. Now, it's a very odd document indeed, and its genesis perhaps explains why it's so odd, because here are two Russian lawyers. They are on holiday, which they use partly for business, in the British Virgin Islands. They get themselves a standard form of trust, and they, not being trust lawyers, that's for sure, and not being common lawyers or equity lawyers or English lawyers at all, and genuinely not knowing about it, fill that in. and they've given an explanation. The judge didn't like it, but whatever it may be, and I can happily repeat the explanation. It was to give authority to Mr. Pleshakov on the part of the shareholders when he already had a power of attorney on the part of the company in case anything went badly wrong. And Mr. Pleshakov said in his oral evidence that he was understood the trust to be something for him in extremis. Anyway, the trust deed sets out the opposite of the alleged intention for Linkov and Kazantseva being trustees and Mr. Pleshakov being the beneficiary. The opposite is there. And as I've already submitted briefly, share certificates are not assets of any trust. They're just evidence of the existence of shares. They don't provide any rights nor powers to the possessor of them, and you do not therefore have a trust fund. Now, if the trust was understood by Mr. Pleshakov to be intended to be evidence of a nominee shareholding, then it would have been otherwise expressed, but it certainly wasn't. But perhaps more important is this: trust deed is prayed in aid in support of the proposition that it evidences an intention on the part of Linkov and Kazantseva to be trustees. And that Mr. Pleshakov received it, he said in meetings when it was all explained to him, but that was wrong, as so much of his evidence. But anyway, he received it. And what did he then do? And it is undisputed evidence that he did exactly nothing. He did not have it translated. He couldn't read English. He did not read it for obvious reasons. He couldn't read English. He didn't sign it. He utterly ignored it. And until April 2013, didn't ever look at it. So whatever it was not something that Mr. Pleshakov believed was an important piece of paper which evidenced an arrangement that he had made with Mr. Linkov and Ms. Kazantseva. He held no such belief. He thought it was a bump of paper which he just ignored. He had a power of attorney which he could operate and which he understood, and this envelope of bump remained exactly that, an envelope of bump. And it takes, in our submission, the case not to one where you can point to this document and say, this shows what they really intended. It does the opposite if it's looked at seriously at all, but it can't actually even be looked at seriously at all because it's such a nonsense. Now, further on subsequent conduct, we refer to the financial relationship at our paragraph 111, page 2360. Mr. Pleshakov had alleged that he paid each of Linkov and Kazantseva 4,000 euros a month directly in consideration of the agreement. That, of course, was wrong. Ms. Kazantseva received director's fees of 4,000 euros. She took those director's fees between April 2007 and March 2013. Those were simply director's fees. Mr. Linkov did not take director's fees. Now, the judge had said in his paragraph 60 that Ms. Kazantseva, who had paid for the incorporation, Mr. Linkov, who had paid for the shares, and Ms. Kazantseva also paid for the shares in Transero because she reimbursed Mr. Linkov, that they would, one way or the other, have been indemnified. And he referred in his paragraph 61 to unquantified cash to Mr. Linkov. My Lord, in our respectful submission, it is not right to simply say, well, they would somehow or other be indemnified. And if they weren't, well, then they have a right to indemnity. That isn't a finding of fact. It really isn't. And the judge in his paragraph 49 at page 13 rightly referred to part of the evidence that dealt with the unquantified cash to Mr. Lincoln. That was, and I quote from the judgment, paragraph 49, page 13, concocted and absurd. And indeed it was. It involved motorcycles and boxes of holding cash and so forth. Now, that evidence, described rightly by the judge as concocted and absurd, was after all concocted and absurd, presented by and on behalf of Mr. Pleshakov. That's what he saw fit to put forward. Having failed to prove his sworn case that he paid each of them 4,000 euro a head as consideration for the agreement. We refer also in our paragraph at page 2361 to the vote. I've already dealt with vote. It was perfectly sensible for the company to authorize Mr. Pleshakov to vote the Transaero shares, not the SkyStream shares, right? Not the SkyStream shares, the Transaero shares, to vote them in a particular way because he was a senior officer of the company and well aware what was in the interest, financial interest. And therefore it would be a given that one would follow those in recommendations and giving him the power to vote accordingly. And people who have investments in shares in their portfolios very often leave it again to their discretionary trustees or trustees to vote those shares because it's in their interest. Now, what we do, however, point to in the context of subsequent conduct, insofar as you take it into account at all as to what happened in December 2005, is that Mr. Pleshakov, and this is common ground, never took any dividends out of SkyStream, never asked for distributions out of SkyStream. SkyStream had over $10 million, never asked for that. He took no interest in finances. He didn't ask for accounts until when the relationship broke out. Asked for no financial information whatsoever. And when he wanted cash, well, what did he do? He sold Transaero shares to SkyStream to raise cash for himself. Now, that is extraordinary, we would respectfully submit, for somebody who owns a company beneficially and needs cash, not to get a perfectly valid, lawful distribution out of the surplus of the company, but to sell the company something so he can get something. We have also in our written case at paragraph 115 dealt with the alteration of the articles. And we submit that directors who are also shareholders may perfectly well make provision for salaries, bonuses, and various remunerations on various eventualities. And nothing that they did in 2010, which was the date of the article alterations of 5th of October 2010, can illustrate, let alone form, the basis of the finding of a bare trust and the plus
if it were a bare trust,
2005. Sorry.
If it were a bare trust, this was using a voting right other than at the direction of the beneficial owner. Would that be right?
Precisely, my lady. And I, if I may respectfully say so, I mentioned that example, that they as directors voted on various resolutions, and this is one resolution which is an example of one that had nothing to do with Mr. Pleshakov.
Well, this resolution would be one in which they were conflicted. Would there not be restrictions on doing that?
Well, my lady, if they are not trustees, as we say, they never were, then there would be no restriction. But if they were trustees, then Mr. Pleshakov, who came on the board with his daughter, would have objected to this, but he didn't.
I see. I thought you said they voted as directors on this.
Yes,
That would be a conflict of interest because the directors are fiduciaries.
The directors are certainly fiduciaries. I will check on that, whether it was a shareholders' resolution or a directors' resolution. We'll check that now. Thank you very much, my lady. Thank you. Now, on the breakdown of the relationship in Munich, there was a meeting on the 6th of March 2013. Judge found as a fact, paragraph 41, that there was no discussion of the Skystream shares at all at that meeting. They were not mentioned. And as I've already said, and I'll say it very briefly, all Mr. Pleshakov needed to do, if he believed that Kazantseva and Linkov were bare trustees, there was a nomineeship, was to require them to transfer the Skystream shares to him. There was no need to transfer the Transaero shares out of Skystream, which he proposed in Munich. There was no need for the ocean shares, Sky Ocean shares, to be transferred out of Skystream. If the Skystream shares had been transferred to Mr. Pleshakov, none of that was needed. But he absolutely didn't ask for that. Why? Because he obviously didn't believe that Skystream was beneficially his and the Skystream share was his. He had an idea that the Transaero shares should be his and the Ocean Sky shares should be his, but not that the Skystream shares should be his. I had cross-examined Mr. Pleshakov at first instance about these documents in Munich and about the transfer documents. And the reference is at the transcripts at page 663. And the learned judge stopped me cross-examining on the basis that there was nothing in the statement of claim dealing with those transactions in Munich. And if I can just quickly pick this up at page 663, I had said at line 8 about the minutes and the handwriting and discussions with Mr. Linkov and so on. And the court says at line 14, Ms. Doman, sorry to interrupt, but is anything transacted at this meeting, this is the Munich meeting, relied upon by the claimant in the statement of claim? Because I can't find anything. And I say, my lord, no, it's not, because it wasn't. So the court, so why are we canvassing all of this? So I then said I would go to another point, which was similar to the one I just made about transferring the other shares. The judge, in my respectful submission, rightly said, well, why are we spending time at trial about what happened in Munich in 2013 in relation to what happened in the British Virgin Islands in December 2005? Why are we looking at this? It's not relevant. Well, I respectfully agree. It is not relevant. So, however, it is now heavily prayed in aid as subsequent conduct of what went on in Munich. But it cannot be relevant.
But, Ms. Damon, I mean, the judge was merely asking why you were canvassing it all. You obviously thought it was relevant, or you wouldn't have been cross-examining about it.
My lord, I was cross-examining on it because great reliance was placed on the conduct of Mr. Linkov, who had been cross-examined, would be cross-examined on it too. And the court says, so why are we canvassing all of this? It was discouraging me from carrying on because it wasn't a pleaded point. He was making it clear to counsel that, you know, why are you wasting court time on a not pleaded point?
Thank you.
I jolly well stopped and put the other point, which was you didn't ask for the Skystream shares. which was, even that was, strictly speaking, still around that particular area of what happened so many years later. My lord, I would like to come to the separate position of Ms. Kazantseva. And yes. Thank you very much. And they're both with the article. Yes. I'm grateful to my learned junior, Mr. Rattan, in answer to the question of my Lady Arden. The resolution in question about the alteration of the articles, as it would normally have to be, was a shareholders' resolution, but there was a directors' resolution as well. It was both. They actually passed two resolutions. And the bundle references are 1,885 and 1,886. I'm grateful. Now, in our written case at page 2330, we deal with the position of Ms. Kazantseva. Ms. Kazantseva was separately represented, both at first instance at the Court of Appeal by me, and Sir Clive Friedman, as he now is, represented Mr. Linkoff. And he is obviously no longer able to do so, and for that reason, I now represent both of them. But Ms. Kazantseva's position was rather different, because there was really never any case against her that was spelled out. I have already mentioned what Mr. Pleshakov said in his witness statement, and that is at page 220. At paragraph 59. And the board sees that Mr. Linkoff had told me even in 2006, 2007, his health has been declining. This has been true and is common ground that Mr. Linkoff has been very ill a very great deal of the time. He has a serious heart condition. And then if I take it at lines 8 to 9, he was worried about the possible incapacity of Mr. Linkoff running the company. I had not seen Ms. Kazantseva on many occasions and placed no trust in her. So insofar as there was said to be an agreement with Ms. Kazantseva, it was certainly not made as between her and Mr. Pleshakov. There was never a plea that Linkoff was the agent of Kazantseva. There has been an attempt to argue partnership. This was not pleaded, and there was no expert evidence of Russian partnership law. But in any event, it doesn't matter on the facts, because the facts are that it was common ground that Kazantseva and Linkoff held their shares, brackets, Mr. Pleshakov's shares, personally, not on behalf of the partnership of Linkoff and Associates, his firm in Moscow, which was transferred to Germany. And it wasn't a partnership matter or a firm matter whatsoever. So at paragraph 39.1 at page 2330 of our written case, I quote from our skeleton argument at first instance, where we say there is no suggestion anywhere in the pleading or in Mr. Pleshakov's evidence that Ms. Kazantseva was present at any alleged meeting, wherever or whenever that might have been, where the oral agreements alleged to have been made. It is neither pleaded nor asserted in evidence that Mr. Linkoff was the agent of Ms. Kazantseva. No actual, no implied authority, no holding out of Ms. Kazantseva by Mr. Linkoff as her agent are alleged. Had it been alleged, it would have been a hopeless allegation. Ms. Kazantseva has made no agreement to act as nominee shareholder and is bound by no such alleged agreement. And we then set out in paragraph 32(9 the reference to partnership law I've already mentioned. And we say in the 5th line, Roman 1, Mr. Pleshakov did not at any stage seek to amend the pleaded case or assert partnership. He did not adduce any Russian law expert evidence. In any event, on Mr. Pleshakov's own case, Skystream shares were held by each of them personally. And Mr. Pleshakov's case was the only consideration agreed between him and Linkoff was he would pay each 4,000. You've heard me say this before. And he readily admitted in his oral evidence he never paid Ms. Kazantseva this monthly sum or anything else. And the transcript, which we had a moment ago, at page 641, the cross-examination where I begin, the cross-examination of Mr. Pleshakov on behalf of Ms. Kazantseva, and I say so at line 24. And he accepts, as we see over the page, that she was never his personal lawyer. And then at line 15, at page 642, she never received any payment from you personally for any legal services, never paid her, never private client. He talks about criminal cases, which had nothing to do with it. And at page 643, line 19, Mr. Pleshakov says, all my relations were always constructive with Mr. Linkoff. And then at 650, I deal with the 4,000 euro at line 1 to 3. And he says at line 7 to 8, I did not give any bonuses or any money to Ms. Kazantseva, and this is true. And he knew nothing about the company paying her anything. That's lines 12 to 13. It is another example about how Mr. Pleshakov took no interest at all in what went on in the company, apart from the trading. And then line 18 to 20, as I've already stated before, I did not advance, I did not pay Ms. Kazantseva, neither this nor anything else. And there we go. So one needed to find both an agreement and an intention forming an intention being formed on the part of Ms. Kazantseva that she was to hold the Skystream shares registered in her name on trust for Mr. Pleshakov. She was asked whether she would hold anything with Mr. Pleshakov, and she denied it. Now, my lords, I'm in your hands as to when you wish a break, but I would now continue with what was the case before the Court of Appeal, and I would then turn to the judgment of the Court of Appeal.
Well, please do. We don't usually take a break in the afternoon,
No,
but if you would like,
I'm very happy to carry on.
Please take it.
If I'm allowed to, yes.
Yes, of course.
So, my lady, my lords, this is a very serious matter for us because we are accused of misleading the Court of Appeal in relation to what the case was about. And that, as a result, the Court of Appeal misunderstood the nature of the case. Now, it's right to say that the Court of Appeal had absolutely everything in front of it. I'll come back to it when we come back to this when we come to delay. But they had all the pleadings, all the witness statements, all the affidavits, all the skeletons, and the skeletons at first instance, and the skeletons for the Court of Appeal. And of course, most important, they had the judgment. So we say at page 2341 in paragraph 67 what the what the submissions were on appeal. And I think it would be right to deal with them directly from the bundle, which holds Mr. Mouskinson's skeleton submissions. And they start at page 366, so far as my reference is concerned. They start actually at 364 at the very beginning. But I only want to pick out references which we have largely set out on our written case, but there are additional ones that I need to refer to. So at the bottom of page 366, paragraph 6, the last line says about Mr. Pleshakov, all he understood was that the company was intended to hold the Transaero shares, and that the shares in the company were held for him, and that is what he had agreed with Mr. Linkoff. Then at paragraph 10 at page 369, I overlooked it. Yeah. The first line, the judge held that the agreement alleged by Mr. Pleshakov and denied by the individual defendants had been made as alleged by Mr. Pleshakov. Then page 370, paragraph 12, the emails show that there had been a plan agreed sometime before mid-December. And again, a plan is, of course, a very wide concept and can be anything, but this was meant to be an agreed plan. And then we have in paragraph 13, in the last 7 lines, the suggestion that any of these documents, that's the trust deed and various others, could have been created without prior discussion and agreement with Mr. Pleshakov is utterly implausible. The agreement had to have been made either prior to or in December 2005. Mr. Linkoff left Russia on about 9 December 2005. Mr. Pleshakov did not abandon his case that there was an oral agreement. Then paragraph 15 at page 371. In addition, the trust deed signed by the individual defendants made it clear that Ms. Kazantseva understood that she held her shares in the company for Mr. Pleshakov as a result of his agreement with Mr. Linkoff and was thus in on the plan. Ms. Kazantseva was a partner in the firm Linkoff and Partners, and she obviously accepted the capacity in which she acquired the shares, and the trust deed is compelling evidence of that. Well, the partnership point is truly wrong for the reasons I've said. Paragraph 18, page 372, it would in fact not make any difference if they had not been paid, that is the various payments Pleshakov wrongly alleged he made. They would have a claim for payment or reimbursement, but that would not affect the fact that they held the shares on trust for Mr. Pleshakov, because that was what they had agreed to do. Mr. Pleshakov had acted on that agreement. And then at page 373, paragraph 20, the individual defendants make much of the fact that Mr. Pleshakov was an often somewhat confused and incoherent witness, but he was consistent in his assertion that the shares were held by the individual defendants, and that was what he had agreed with Mr. Linkoff. And I leave that from the written submissions to the Court of Appeal and go to the oral submissions made to the Court of Appeal, but rather than taking them from the transcript, which came out very faintly, we set it out in paragraph 69 of our written case, which is at page 2341. And we there refer to the written submissions made, the oral submission, I apologize, made by Mr. Mouskinson. And he said, paragraph 69, the italic quotation, the issue the judge had to decide really was there an oral agreement, arrangement or agreement? Now, my lords, you could not really have a clearer statement than that that's an issue the judge had to decide. we are told, it is said of us that we misled the court that that was the issue. It was the issue. It was the issue. And Mr. Mouskinson made it very clear to the Court of Appeal that it was the issue. It doesn't really matter in this context because we're dealing with proprietary rights here. And we say the agreement was that Mr. Linkoff, Mr. Pleshakov is quite clear about this. He spoke to Mr. Linkoff. He was the partner he dealt with. He spoke to Mr. Linkoff and the agreement was made that a company would be formed, etc. And then the next passage, we submit that the judgment of the judge accepts that the agreement was made. He set out the facts, the conventions in the conversations in the BVI. And then when he comes to the discussions he holds, there was an agreement along the lines of put forward by Mr. Pleshakov. Then at the top of page 2342, in cross-examination, Mr. Pleshakov did not abandon his case that there was an oral agreement. He just didn't know when, where, and so on. Next passage, Mr. Pleshakov in evidence never gave up the point that throughout he acted on the basis of an agreement, and Mr. Linkoff and Skyscream was to be held for him. Then we deal with the €4,000 again in the next passage, and the consideration, and the last line say if consideration is needed, once they'd agreed to hold the shares on trust, actually that was really the end of it, because people acting on the basis of it, it's a proprietary claim, and that's really it. So plainly we submit plenty of evidence for the judge to find an agreement. The shares would be held, and it wasn't in any way perverse finding. It wasn't a finding made in the absence of evidence. It was a finding that was open to him to make on having heard all the evidence. The question is, what was agreed when they left for the BVI? Judge found, when you read his judgment carefully, he set out the facts and the conclusions. Obviously, he found there was an agreement that these shares were going to be held for Mr. Pleshakov, and in my submission, your lordships, there is nothing, and so on. So we deal in paragraph 70 with our answer to the misleading point, and that the Court of Appeal misunderstood the case. Now, we have set out in our written case at page 2317 to 29 why we submit that the Court of Appeal was correct. And my lords, rather than go to that because you have our written case, may I take you to the judgment of the Court of Appeal? And we have that. Starting at page 23. Thank you. My lord, the judgment itself after the headnote starts at page 4. And the board will bear with me when I make only references to certain paragraphs without reading it all, because of course one can't given our time. But in paragraph 1, we have a correct, we submit summary of what the case was about, and refers to in the middle of that paragraph to the shares being acquired by Skyscream as nominees for Mr. Pleshakov. And then paragraph 2, the last 4 lines, Pleshakov submits that the judge's conclusion that he's the beneficial owner of the shares accords with the witness evidence, documentary evidence, the manner. They had all that clearly in their mind. It was clear. I really must repeat that they had the whole record, an enormous amount of paperwork. What they did not have is 77 authorities, they had 16. Now, the Court of Appeal then set out the background in paragraph 3, and again, it is correctly summarized what the allegations were, and the arrangement, and so on. And paragraph 4, Mr. Pleshakov claimed that on his instructions and pursuant to the agreement between him, they were sent and so on. Deed of trust was executed. Party explained the document in different ways. Pleshakov alleges the deed was evidence to trust over the shares. It was all in front of them and clear to their mind, and therefore consistent with the nominee agreement. Paragraph 6, Pleshakov alleged in keeping with the nominee agreement between him and the plaintiff appellants, he paid so much money. But of course, that didn't work. 7, Pleshakov alleged that shares would be acquired for his sole use and benefit. Paragraph 8, again, Mr. Pleshakov claimed due to a breakdown in trust between him and Linkov, he wished to bring the nominee agreement to an end. At paragraph 11, the appellants denied that there was a nominee agreement. 12, what the learned judge found on the evidence that the Skyscream shares were held by nominees of Mr. Pleshakov. And over the page 8, still in paragraph 12, halfway through the paragraph, the judge stated it was more likely that the incorporation of Skystream was done at the request of Mr. Pleshakov. Judge opined that the terms of Mr. Linkov's email, and you've seen that email, chime very well with that. So they had that case, they had it. Cannot be said that they didn't have the case in front of them. Then the case on appeal, and we set out the grounds of appeal are set out, and I would go to page 10, paragraph 20, the appellant's arguments, oral agreement, 5 points. And paragraph 20, the appellants contend that in appearing to accept that there was an oral agreement, the judge drew inferences and or made evaluations from the evidence which were wrong. And then we say at the bottom on page 10, as ordered by the Court of Appeal, that Mr. Pleshakov failed to prove his case, that he had not even attempted to establish a case against Ms. Kazantseva, and the judge should have dismissed the claim in its entirety. We then have the points that we made set out in relation to the appeal, and it refers to the time and place of the oral agreement, and we refer also to Ms. Kazantseva and the grounds of appeal. And in paragraph 22, at the last line, Ms. Kazantseva was not said to be and was not part of such telephone conversations, which is indeed the case. But then we have a ground of appeal about the funding of the trip to the Caribbean and the payment of the monthly sum in the middle of paragraph 25. None of this happened, and you have those points. And at paragraph 29, we deal with the 5th element, and the last 3 lines read, the appellants submit that there would be no reason for bare trustees to bear such expenditure themselves, and the fact that they did shows they were beneficial as well as legal owners. So the bare trustee point was also mentioned, both in my submissions and Mr. Friedman's submissions, and by the Court of Appeal itself. Then in paragraph 30, we have the reference to what the judge stated, which you have already seen and heard, about the entitlement to indemnification, including reference to Ms. Kazantseva. They were clearly entitled to be indemnified if they hadn't been paid. And then it says in 31, the appellants contend that the case is a peculiar one and is based largely on the judge's evaluation, as demonstrated by the way in which he has rejected large parts of Mr. Pleshakov's evidence. That is true, a very great deal was rejected. And yet found an oral agreement without identifying how, where, and when it was made. The appellants posit that the judge's evaluation was wrong and invites this court to re-evaluate the same material, being in as good a position as the trial judge was to carry out that evaluation and review the decision below and come to a different conclusion. Now, the court then deals with Mr. Pleshakov's position. And if your lordships would be so kind, my lady would be so kind to look at paragraph 32, you have all the points there that there was the oral evidence, there was a 4.5-day trial, the implausibility of the appellant's case, the inconsistency in later conduct, and documentary evidence that they were the beneficial owners. And in the last sentence, Mr. Pleshakov admits that the issue the judge had to decide was whether there was an oral agreement. And the judge accepted that an agreement was made for the reasons paragraph 53 and 54 of the judgment. So again, the Court of Appeal directed itself to what it was being told on behalf of Mr. Pleshakov was the issue. Then we have the law on finding on facts. Now, it's submitted on behalf of Mr. Pleshakov for front of the board. But here, the Court of Appeal are simply paying lip service. And we see at paragraph 33, the arguments raised engage the legal principles governing appellate interference with factual findings of a judge. And they then cite authority, which of course I won't read, but you see what they have cited and what they have emphasized about conclusions of fact and what are conclusions of primary fact and so on. And they also particularly emphasized in paragraph 35 the words of my lady, Lady Justice Arden, as she then was, in Langsom, and it's fully set out. And we have got paragraph 36, the judgment of Lord Hodge. My lords, I don't go through all of that, but you see that they have set it out. And we respectfully say that it's quite wrong to accuse them of paying lip service, because this was argued before them, and they had it. Then we have the discussion at paragraph 40. A critical issue in the appeal is whether the judge was wrong in finding that the appellants acquired the Skystream shares as nominees for Mr. Pleshakov. Again, that's the question. They're asking the right question. This necessarily engages the law with respect to appellate interference with factual findings and the judge's evaluation of evidence. And then they look at this, and they refer in the middle of the passage to the existence, time, place of the oral agreement and the ownership of Transaero shares. At paragraph 41, the appellants point out that nowhere in the judgment is there a finding of primary fact that there was an oral agreement. That is now accepted on behalf of Mr. Pleshakov, but it wasn't at the stage of the Court of Appeal. At paragraph 42, then there are our submissions and about the inferences that were supposed to be drawn in relation to the Transaero shares, namely the price that was paid for them by the company, and of course the other payments made by Kazantseva and Linko. Then at paragraph 43 is our submission that the appellate court is able to make this evaluation itself without being at a disadvantage by not seeing the witnesses. By way of example, the learned judge found in Mr. Pleshakov's case that there was an entitlement to indemnification. Although the learned judge thought it was likely that indemnification would have occurred, there was, however, no evidence of reimbursement. If the acquisition of the Transaero shares was by Skystream in circumstances where Mr. Pleshakov, not the appellants, owned Skystream, then the purchase price would have been paid by Mr. Pleshakov. However, it was demonstrated that the appellants paid the money, and there is no evidence to show they were indemnified. This is absolutely right. On evaluating the matter, I conclude that the appellants' payments went a long way, demonstrating that the appellants were the beneficial and legal owners of the shares in Skystream. Then we posit that the judge balanced the payments they made against fees received by Ms. Kazantseva. The judge got that quite wrong. He got the figure seriously wrong, but he thought that somehow Ms. Kazantseva would be compensated. That's paragraph 44. And 45, the appellants point to another example of fundamentally wrong evaluation. This related to the issue whether Mr. Pleshakov was the beneficial owner of the Transaero shares, which were acquired by Skystream. The appellants posit that the judge's evaluation was self-contradictory. My lords, I maintain that submission. At one point, the judge regarded the issue of whether Mr. Pleshakov owned the Transaero shares as not the issue before the court. Quite right, it was. Issue was the Skystream shares. At another point of judgment, the judge treated the issue of Mr. Pleshakov's ownership of the Transaero shares sold to Skystream as very important indeed. In my judgment, the judge's evaluation was flawed because this ownership issue should have weighed so heavily as to disprove the alleged oral agreement, whether by itself or alongside other factors, such as the payment of the incorporation fees and the acquisition costs. The appellate court is in as good a position as the judge to carry out the evaluation itself and come to an opposite conclusion to that of the judge. I agree in paragraph 46 with the appellants that on the judge's finding that Mr. Pleshakov had failed to establish that he had ever acquired a beneficial interest in any of the shares formally held by the BB Group, including 19.99% of Transaero, which was transferred to Skystream on the 31st of March 2006, it was not open to him to find that Skystream had been incorporated as part of a plan to disguise such beneficial ownership, because he didn't have it. So I mean, if suddenly he became the beneficial owner of the Transaero shares by dint of Skystream, he literally got them for free because he didn't previously own them. It was also inherently self-contradictory for the judge to reason that Mr. Pleshakov would not have parted with the Transaero shares when he had never owned them and they were never his to part with. The learned judge recognized how fundamental this point was in the course of his final oral submissions, that is, the exchanges that took place between counsel and the learned judge on the last day. And Mr. Pleshakov's case was shattered, not least in consequence of not owning the shares. That is what happened, and we complained to the Court of Appeal. The judge changed his mind. The Court of Appeal quite rightly says at the end of their judgment that the judge was entitled to change his mind. And paragraph 47, as the appellants posit in his written judgment, the learned judge sought to marginalize the issue of whether the Transaero shares were those of Mr. Pleshakov, saying that the only issue was whether the appellants acquired Skystream as nominees to Mr. Pleshakov. And Mr. Pleshakov had agreed with the judge's definition of the issue. The appellants submitted, I agree, that this was to ignore the whole basis of Mr. Pleshakov's case, and you already have my submissions of this, and you see then the reasoning and the citation of the very important paragraph 12 of the judge at trial. Mr. Pleshakov's case boiled down to its essential was Transaero shares belonged to him beneficially. That was his case, and the Court of Appeal could not be impressed by the fact that that important plank of his case was dropped and reduced to the status of a red herring at the appeal. Then 48, I agree with the appellant's submission that the learned judge should have found that the whole base of Mr. Pleshakov's case was destroyed by the fact he did not own the shares. Mr. Pleshakov's inability to establish the oral agreement, that is the last 6 lines of paragraph 48, and the fundamental building block of the ownership of Transaero shares meant that the case fell apart. It literally did at the hearing during the trial, but then the judge came nonetheless to the judgment he came to. On looking at the inherent probabilities of the case and the objective facts, in my view, the oral agreement has not been established and the judge was plainly wrong in his conclusion. And then at 49, there's much force in the appellant's submission that the judge's rejection of Mr. Pleshakov's pleaded case as regards the time, place, and existence of the alleged oral agreement, the sending of the respondents at his expense to the BVI, the ownership of the shares, and so on. Evidence was unsatisfactory and unreliable, and it was on very many different points. We then come to subsequent conduct, paragraph 50, page 22. And their citation from the judge is paragraph 52, which you have seen. What the sole question is: arrangement, nominee, circumstance, and then what is then relevant is the circumstances surrounding its acquisition of ice cream, which will have the most bearing upon the resolution of that question. Circumstances surrounding the acquisition. The learned judge found that the evidence established that the appellants acquired the SkyStream shares as nominees, and nothing that happened subsequent to that acquisition is inconsistent with that finding. So it was referred to as a point of consistency. My lords, at paragraph 51, the Court of Appeal deals in more detail with the payments. You see from line 7 onwards, the 4,000 euros again. It sounds as if that's what was not so important, but it was at first instance, because Mr. Pleshakov had pleaded this as his consideration for the nominee agreement. Then in paragraph 53, Mr. Pleshakov referred us to various points of subsequent conduct which he contends are consistent with his being the beneficial owner and the appellants holding the shares as nominees. And then our submission: the appellants submit, and I agree, that it does not suffice to prove a case where mere consistency of matters years after the acquisition of shares is far less telling than the 5 points that we had listed, which are about the circumstances of and relating to the acquisition of the shares in SkyStream. They still deal with that in paragraph 54, and over the page 24, at the top. An important feature of the analysis is that whilst Mr. Pleshakov and his daughter became directors of SkyStream, they did not participate as such, save to approve a resolution on the 12th of December 2011, permitting Mr. Linkoff alone to form a quorum for the purpose of board business. This is inconsistent with the beneficial ownership of Mr. Pleshakov and SkyStream. Similarly, the fact Mr. Linkoff voted alongside Mr. Pleshakov in respect of the Transaero shares is consistent with collaboration between two persons. And again, I don't read everything, but paragraph 55 then deletes with the looks at the original share certificates, which were sent to Mr. Pleshakov. And although the judge recognized that the share certificates were not the equivalent of shares themselves, he reasoned that the fact that Mr. Pleshakov held them would have put very considerable obstacles in the appellant's way had they attempted to transfer the SkyStream shares to a third party. The judge rejected the appellant's evidence, and your lordship see that. And he had had them for 10 years, Mr. Pleshakov, and they weren't asked to be returned. And they set all that out. So they had it in mind, it was put in front of them. Then 56, Mr. Pleshakov relies on the fact that within days of the formation of the company, its most important documents, and there we have certificate of incorporation, memorandum, articles, power of attorney, trust deed, they were sent. Mr. Pleshakov submits that the suggestion that any of these documents could have been created without prior discussion and agreement with Mr. Pleshakov is utterly implausible, and that the agreement had to be made prior to or in December 2005. Mr. Pleshakov argues that the appellants were unable to offer any plausible explanation as to the purpose of execution of the trust deed. And there's then reference to the fact that they were not bearer shares, but registered in the appellant's name, those shares, in paragraph 57. In paragraph 58, the deed of trust is specifically referred to. The learned judge's findings on the deed of trust and the circumstances surrounding its execution constituted a central plank in the overall finding of the shares of SkyStream were being held on trust by the appellants for Mr. Pleshakov's benefit. He found that deed of trust is compelling evidence that there was the intention of the defendants that Skystream was to be and remain under the control of Mr. Pleshakov. So again, that finding was before the Court of Appeal. The Court of Appeal addressed itself to it. While noting that the document did not create any trust with the Skystream shares, the learned judge formed the view that the deed of trust might be of tremendous importance to Mr. Pleshakov in the event that something untoward befell either or both of the appellants. He also considered the fact that if the appellants intended to own the Skystream shares in personal capacity, the trust deed would have been unnecessary. And we then have in 59 the attention that there was a problem with Russian law. And at 60, Pleshakov first brought the proceedings in May 13 to obtain a stop notice, and he then did that on the basis of the deed of trust. But it says then 6 lines down, Mr. Pleshakov had abandoned this trust case and relegated deed of trust to alleged evidence of the agreement. And that, of course, is right. And there's further discussion in relation to this. Then paragraph 61, the appellant submit that the judge, having rightly found that the reported deed of trust did not create any trust, erred and misdirected himself when he went on to make findings without any evidential basis about the use of and instructions of a BVI lawyer and relative probability of the use of a Russian lawyer in respect of the trust deed. The appellant submit, and I agree, that the references made to emails and the trust deed do not provide a basis for the claim, because they do not make out an agreement Mr. Pleshakov had long ago abandoned his case on the trust deed, from it allegedly being evidence. But he never looked at it, he never believed in it, nothing. Then we have paragraph 62, the comments on the course which suggests that Mr. Pleshakov's case was fundamentally defective. The absence of evidence Mr. Pleshakov ever owned the Transaero shares, the purchase of the Transaero shares by Mr. Pleshakov from Skystream when he needed money was inconsistent. The payment by Mr. Linkov with Kazantseva for the acquisition of Skystream itself and of Transaero shares, the concern of Mr. Pleshakov being limited to the remaining Transaero shares and not to the assets of Skystream. The judge did note that, and it is very important. And the Court of Appeal noted it too, had the same material. If Mr. Pleshakov had owned the Skystream, his concern would not have been so limited. Indeed. Now, my lady, my lords, in the rest of the judgment, the court say, well, the judge is entitled to change his mind, so that ground of appeal is not allowed. But the appeal...
Sorry, I'm so sorry.
Yes,
before you leave the judgment, could I just put it to you that paragraph 57, saying that the possession of the share certificates gave no power or right to the possessor,
yes,
is really missing the point. The point is that without the share certificates, it's unlikely, I haven't got the articles, that the shares could be transferred and they couldn't be the subject of an equitable charge, so that the respondents, if they were minded to use the shares as security to raise funding, wouldn't be in that position. Likewise, the company's seal is rather important, isn't it? That was delivered to Mr. Pleshakov. These are important formalities which the respondents would not. It's an important tool of the company, and the share certificates are important.
My lady, that is right. And the share certificates, as I have previously submitted, they don't give any rights and ownership rights at all in themselves. They don't form a trust fund. But not having them may be some disadvantage to the directors of Skystream and the shareholders of Skystream. It never arose. They did provide them, and they never denied that they did. Equally, Mr. Pleshakov never denied that he ignored the fact that he had the seal, the share certificates, the trust deed, totally ignored it as being wholly unnecessary from his point of view. just irrelevant, and didn't look at this
That's
until.
not quite the point, is it? The point is, what inferences do you draw from the delivery of these items to Mr. Pleshakov?
Yes, that was, according to Mr. Linkov, that Mr. Pleshakov should have the ability to represent the company if it came to it. And Mr. Pleshakov himself said that he was given these things, as he understood it, in extremis, if something happened to Mr. Linkov.
But the judge, having heard Mr. Linkov, rejected that evidence. And I don't think there's a finding by the Court of Appeal that he was wrong to do so. And it leaves, bearing in mind that both the trust deed and the handing over the share certificates and the seal are all about what they show about Mr. Linkov's intention, not Mr. Pleshakov's intention. How do you fill the gap left by the trustee, by the judge's rejection of the only explanation which Mr. Linkov gave?
Well, my lord, that is because there wasn't otherwise material to show that both Mr. Linkov and Ms. Kazantseva had actually set out to become registered shareholders of SkyStream for the purpose of holding the shares for Mr. Pleshakov.
All right.
Now, I was going to.
You've got about 9 minutes, Miss Doman. That's giving you the full benefit of the extra 5.
I'm so grateful, my lord, because I can do it in 5.
That's fine.
It is the delay point, which was mentioned without being developed. And we deal with this in our case very briefly at page 2329, paragraph 38. And yes, now we submit this. Firstly, there is really no basis for suggesting that the Court of Appeal may no longer have had the entire record and the material in front of it. There's really no basis for it at all, very much the contrary. And also, when we received the record from the British Virgin Islands, it was complete. They would have had the same record. It still has the Court of Appeal numbering. It is pure speculation to suggest that the Court of Appeal may no longer have had the entirety of the record. As to prejudice of the delay, prejudice is not necessarily suffered by the person who loses the appeal. Here there was no stay of execution. Mr. Pleshakov was in charge of SkyStream all the years between first instance and the Court of Appeal. And Mr. Linkov, Ms. Kazantseva say they lost everything. There was no stay of execution. So the prejudice was all on their way. But the real point is this, is it not, my lord, my lady? What is the concern where there is a great delay? The concern is that a fact-finding judge will have lost the advantage of seeing the witness, where a higher court has everything on paper only. So here, where you have enormous delays sometimes between first instance and appeal, then you can see a great disadvantage indeed once it comes to your appellate stage. But it is different when you have an appeal court acting on the record and then a higher appeal court acting on the record. My lords, I don't have time to develop the authorities we have cited in our paragraph 38, but you have them, and they are, of course, including authorities of the board, for which we are grateful and by which we are guided. And I thank you very much. And if you have any questions of me, then I will be happy to try and address them.
It doesn't look as if there are any further questions, unless I've missed someone. No, thank you very much, Mr. Owen, and for finishing so well on time. Yes, now, Mr. Levy.
My lord, I'll be very brief. My lord, on the point of delay, we haven't developed that argument. The board has our arguments. I can say, and this may be a bit cheeky, as a litigator, one feels extremely uncomfortable to receive, and mercifully it doesn't happen terribly often, a judgment more than a year after a matter has been heard. 2 years, 3 years, 3.5 years is an extraordinary period of time, leaving litigators feeling really quite queasy about things. But that said, we accept the burden of the authorities on delay. That is not our primary ground of appeal. Lady Lords, can I address what we suggest is really the big picture point, and then I'll pick up on a few of the points that my learned friend Ms. Doman made. This was a case decided by the judge on the basis of live evidence after a 4-day trial. It turns entirely on the judge's factual determinations and evaluations about the respondents' intentions when they incorporated SkyStream, and the judge's ultimate finding that this was done at Pleshakov's request and was intended by the respondents to be for Pleshakov's benefit. Those factual determinations and evaluations were, at the very lowest, properly owed to the judge for the reasons we explored and explained this morning. We suggest that the Court of Appeal had no proper basis for interfering with that judgment, and that the points advanced by my learned friend both before the Court of Appeal and before the board are nothing more than an attempt to raise an arguable case, which had already been rejected by the trial judge, following evidence, following cross-examination, following arguments, and rejected by him for cogent reasons, which hang together perfectly comfortably when one reviews the first instance judgment. And that is a fundamental reason why, in our submission, the trial judge's judgment should be restored. Furthermore, the respondents still have no credible basis to explain why this company was incorporated in the circumstances in which it was incorporated. Nor do they have any cogent explanation for the production of the deed of trust or the subsequent conduct of all the parties, if, as they would have the board believe, the SkyStream shares had been owned beneficially and had intended to be owned beneficially by the respondents all along. For the reasons that we gave this morning, the respondents' case is simply incredible. So dealing with that's the big ticket point, the big picture point. Dealing with some of the points my own friend made in argument, she dealt with the prior ownership of the SkyStream shares. And she continues to assert, or the respondents continue to assert, that at trial it was somehow a fundamental part of Pleshakov's case that he owned the Transaero shares before they were transferred to SkyStream. Well, we say that's wrong. We say it's wrong for the reasons that we developed this morning, namely that it's the very opposite of what he would wanted to have achieved, because that would have triggered the automatic obligation to offer to buy out the remaining shareholders. It's the opposite of what we wanted. And additionally, when this was raised in cross-examination, Mr. Pleshakov made his position absolutely clear. He did not claim to have been the owner of the Transaero shares before they were transferred to SkyStream. If I can pick up the point that my Lady Arden made to Ms. Doman, it's all about, his argument was all about control. If, and I'm sure you've done this, but do look again at paragraph 116 of our written case, where the burden of Mr. Pleshakov's evidence was, look, I negotiated it. I agreed the terms. I agreed the price. I agreed all of that. And most importantly was I could direct where the shares went. And I think that, and that chimes with what my lady said earlier this afternoon. He could direct where it went. So it wasn't part of his case that he was the legal owner of the shares. It was part of his case that he owned 44 or whatever it was % beforehand, He had an opportunity to acquire the Berezovsky Group's 44 whatever %. Of that, he negotiated all of that, but he was in a position to direct where the shares went, and that's his case. It wasn't part of his case in evidence at trial, and he was very clear on that. Do look again at paragraph 116 of our written case. Then Ms. Doman made a number of points about the value of the Transaero shares. She argued that the learned judge made no specific findings, or made no findings on this point. The judge, in fact, made a specific factual finding at paragraph 25 of the first instance judgment, that the 1% stake sold to Mr. Tereshchenko by Skystream for $20,000, and I think that was about 6 months after, I think it was in October 2006, so about 6 months after the shares were transferred to Skystream, was sold on. The learned judge found that those were sold on for $5 million, and there's never been a finding against that. Ms. Dolan referred to the fact that apparently the Transaero Finance bond documents said the company was heavily indebted. If I could be afforded the same privilege as Ms. Doman about explaining what we all do or don't have with our personal bankers or whatever else, it is actually the case that there are very large companies whose shares trade for vast amounts of money that haven't yet turned a profit. I can refer to Tesla, I think, and I think it's absolute privilege. And also I think it's Uber that's never actually turned a profit. So I mean, that's something and nothing. But we do know that there was a transaction 6 months after the Transaero shares were transferred to Skystream for $5 million. Ms. Dolan said that all of the subsequent transactions were with family or associates of Mr. Pleshakov. That's wrong. As the judge found at paragraph 27 of his judgment, in January and May 2008, Skystream sold a total of 6.5% stake to two external companies. You'll have seen this in the judgment, Fiendo and Roinco, for a total sale price of more than $24 million US. Moving on to the next point, proving that a trust exists. Ms. Dolan argues that in order to prove that there is a trust, one needs to put all the duties of trustees exhaustively to the alleged trustees at trial. We suggest again, with respect to her, that's wrong. It was clearly put, and you've got this in the aid memoir, it was clearly put in cross-examination to the respondents that they intended to hold the shares on trust for Pleshakov as a beneficial owner. And it was put to them that they produce a deed of trust and provided the share certificates and the seal and whatever else in order to demonstrate that intention. Nothing was required for the purposes of establishing Mr. Pleshakov's, nothing more rather was required to establish Pleshakov's entitlement to relief. Moreover, the only management done by the respondents was as directors of Skystream. Nothing else was done for our shareholder, save, as Ms. Dolan pointed out this afternoon, that one of the resolutions was a member's resolution in order to give the directors, who apparently own this company, which is stuffed full of millions of, I mean, at one stage, $24 billion, but tens of billions of dollars, in order to give those directors, who are supposedly the beneficial owners of the shares, the right to a huge amount of money should their directorships cease. That's a very, very odd transaction. And that's something which the learned judge addressed and drew certain conclusions from, having heard the evidence. The suggestion that you can't force a nominee to do anything other than convey the property. That's something we addressed this morning. It may be technically true that where one has a bare trustee, strictly so called, he or she cannot be forced to do anything other than transfer the shares at the order of, or transfer the trust property rather, at the order or direction of the beneficial owner. In fact, Ms. Doman rode back a bit from that when my Lady Arden put a point to her and said, oh, well, maybe they can insure the property. But these are practical commercial transactions. And if somebody is receiving cash-filled envelopes to be a bare trustee, then he doesn't say, when he's asked, will you please vote these shares in a particular way, or will you sell these shares to Roynco for $12 million? He doesn't then carp and say, oh, well, I haven't got to do that because it's not, it's more than my job's worth, or it's not in my job description. That's not what happens in reality. The reality is that he or she does it. And if they don't do it, then the cash-filled envelopes stop flowing and the appointment is terminated. For the lack of specific finding of contract or lack of reasons, there's nothing in that. I mean, the case that springs to mind, and I may be wrong, is English, Reinbold and Emery. If there were any concerns that on the part of the respondents that Justice Bannister didn't set out in detail why it was he held that they were trustees, then the correct approach, and I think that's the right case, but my lady, my lords, will be more familiar with them than me, is if it's a lack of reasons case, a disappointed litigant is meant to go back to the trial judge and say, excuse me, could we please have better reasons? But that's not what happened here. They fully understood what it was, but they set up this kind of Aunt Sally of the agreement. And on that point, you were taken this afternoon to Mr. Malshenson's submissions, oral submissions in the Court of Appeal. He did say agreement, but he also said agreement or arrangement. It doesn't matter. I haven't got the text in front of me. It doesn't matter because this is proprietary. And that's the point. The trustees, well, why bother with this document? It doesn't help the appellant, the respondents rather, that Pleshakov never read it. The question is, why did it come into existence? Why did a document which essentially, like the equitable mortgage type scenario, allowed the trustee to fill his name in Schedule 3 or whichever it was, I think maybe 2, but whichever schedule is for the beneficiaries, exclude the entire world and then appoint himself under paragraph 5. There's no credible explanation for it. One point that we haven't focused on, but which is mentioned in our written case, is what I might call Mr. Linkov's servility. And you'll doubtless have picked this up, but if I could just run through a few points.
You're very short of time.
I'll do it. I'll do it in a minute and a half, if I'm allowed to.
Right.
Linkov and Kazantseva were utterly servile towards Mr. Pleshakov. Linkov wrote in his 9th of September 2010 email, see page 2168, that all of Mr. Pleshakov's instructions would be quote unquote rigorously performed. Linkov, who was a 50% owner of a company which at the material time had many, many millions of dollars sloshing around in its bank account, wrote to Mr. Pleshakov asking for help to pay his children's school fees. That is not the beneficial owner of a company, or half beneficial owner of a company with millions of dollars. For your notes, 2174 to 5. Linkov, who owned apparently 50% of a company that owned 20% of an airline, wrote to Pleshakov, essentially asking him if he could get bumped up into a premium class or an even more premium class when traveling. C2173. Ladies and lords, those are not the marks of somebody who's a beneficial owner of 20% of the airline, or director of a company that owns 20% of the airline, or the mark of a man who is worth squillions. Unless I can assist the court further, those are our submissions.
Thank you, Mr. Levy. Well, thank you and Ms. Doman, and indeed all your teams of counsel and solicitors for the thorough way in which you presented your cases, both in writing and orally. and for your ability to stick with what turned out to be quite a tight timetable. The board will now take time to consider what advice to tender to Her Majesty, and will let you know in due course when it's ready to do so. And meanwhile, the court is adjourned.